Okay, so let's resume our presentation. I had to apologize for that brief interruption. And so let's talk a little bit more about the Fourth Amendment. Okay, the first thing to keep in mind is the Fourth Amendment does apply to businesses. Businesses have many of the same rights with respect to the Fourth Amendment as do private citizens. If a investigator shows up at your business and wants to look through your business records but doesn't have a search warrant, you can require that they go get a search warrant. Well, what is a search warrant? Again, we have one of these yellow terms, so be sure, I'm not yellow, but the red terms, be sure to be familiar with these terms as you take quizzes and tests. These are obviously the source of many of the quizzes that we'll have. So what is a search warrant? It is a court order that authorizes law enforcement agents to search for or seize items specially described in a warrant. And the only way that you can get a warrant, be it a search warrant or an arrest warrant, is that there has to be probable cause. So this is a protection that we have as individuals, but it's also protection we have if we are a business. So let's go on to the Fifth Amendment. Let me just pull up the Fifth Amendment too. Here we go. This one's a long one. There's lots of provisions to the Fifth Amendment. There's some that you probably are more familiar with than others. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Here we go. Except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall, so that's the first one. So we'll call this the indictment, grand jury one. Nor shall any person be subject to the same offense be twice put in jeopardy. This is the double jeopardy protection. So this is one, this is two. Nor shall be compelled in any criminal case to be a witness against himself. So this is self-incrimination. Nor be deprived of life, liberty, or property without due process of law. This is number 4. Call this due process. Nor shall private property be taken for public use without just compensation. This is what's called the just compensation clause or the eminent domain or condemnation clause. So we have 5 different protections. They're not tremendously logically connected. Some of them are, but many of them are not tremendously logically connected to each other. So they're a little bit of a hodgepodge. Let's go back to our slide. Here we go. Okay, so we have the right not to testify against ourselves, but this is a right only natural people, only human beings have. So let's say you are the CFO of a business and there's been some allegation that there's been financial improprieties. You and the business have both been indicted for a crime. You've been called to testify. Well, you don't have to testify. I mean, you have the right to testify if you want to, but if you choose not to, you can't be forced to testify if that testimony would tend to incriminate you. Because you're not testifying, that might be a good thing for the business, but the business doesn't have a right against self-incrimination. For one thing, a business can't testify. It can only testify through human beings. Now let's switch up the facts a little bit. Let's again say you're the CFO of the business. You are indicted. The business is indicted. You inform the district attorney that you plan on claiming the right against self-incrimination. You plan on starting the Fifth Amendment. So the DA decides to give you immunity from prosecution for your testimony. Now you have to testify. The Fifth Amendment isn't going to stop you from testifying. So the testimony that you provide implicates you, but of course that doesn't hurt you at this point because the evidence can't be used against you. But it also implicates your business or the business that you're the CFO of. And so as a result of your testimony, your employer, your company becomes convicted. And so the DA would not be required under those circumstances to give the business immunity. Then we talked about double jeopardy. This is the idea that you cannot be prosecuted criminally twice for the same offense. Now, there are some exceptions to this idea. Two important ones I want to bring to your attention. The first is that if there is a hung jury, then that person can be retried. You could only, the only time that a trial is prohibited, or second trial is prohibited, is when in the first trial the person was acquitted. The second big situation in which double jeopardy isn't an issue would be if a person is tried for a crime that had different elements a second time. Now, generally speaking, if it's a very close, if it's about the same transaction, you can't retry the person. If the person, say, was tried, well, imagine this. Let's say I killed Bob. I'm tried for the crime of killing Bob. I'm acquitted of that crime because of reasonable doubt. There was some reasonable doubt this happened in Texas State Court. Well, now the DA wants to try me for attempted murder. Well, it's about the same event, about the same time that I actually did kill Bob. And so I could argue, probably successfully, that that jeopardy attached in the first case and that I cannot be retried criminally for that case. There is, however, a category of cases that can proceed that we don't consider it being a double jeopardy situation. Let me give you an example. This didn't actually happen, but it could have happened, and it would have been okay. It would not have been a constitutional problem if it had happened. You may recall the case involving a defendant by the name of George Zimmerman in Florida. Mr. Zimmerman was charged with the murder of Mr. Trayvon Martin, who was a young man who died while he was with Mr. Zimmerman. Mr. Zimmerman claimed it was self-defense. Many people felt that it wasn't a true self-defense situation, but of course the jury acquitted Mr. Zimmerman. Maybe the burden was beyond a reasonable doubt, so pretty difficult to prove that somebody that there wasn't some possibility of this self-defense. So, well, at that time, Mr. Zimmerman had been tried for a state crime, murder. I don't know what variety of homicide it was, but some category of homicide. At that time, the Attorney General for the United States was a gentleman by the name of Eric Holder. Eric Holder considered charging Mr. Zimmerman with a federal offense. Now, murder is not a federal offense, but violating someone's civil rights is a federal offense. And certainly if one kills another person, then the person who is deceased, obviously his civil rights have been violated because he's not alive anymore. You can't do anything if you're dead, obviously. But even though it's the same transaction, it would be the same evidence, because in order for Mr. Holder to be able to persuade a jury to convict Mr. Zimmerman of this violation of civil rights, Mr. Holder would have to prove at least one more fact than would have to have been proven in the state court. One thing that wasn't necessary in the state court was to demonstrate that Mr. Zimmerman had some kind of racial animus against Mr. Martin. Mr. Martin was an African-American male. Mr. Zimmerman, I believe, had some Hispanic ancestry, and I also think maybe some European descent. I'm not entirely sure, but he wasn't African American. Anyway, but in order for Mr. Holder to, or the federal court jury would have to not only find that Mr. Zimmerman had in fact taken Mr. Martin's life unlawfully, but also the jury would have to be persuaded that the reason that Mr. Zimmerman took the action that he did was because of some level of racial animus towards Mr. Martin. Now, Mr. Holder decided not to pursue that matter. I'm not sure why, but he didn't. But the reason that he chose not to probably wasn't because he was concerned about double jeopardy. He was probably more concerned about the likelihood of him being successful. After all, if the state of Florida was not able to persuade the jury that Mr. Zimmerman was guilty of murder, it seems perhaps less likely that Mr. Holder would be able to persuade a jury of murder plus one more fact. So that's how double jeopardy works. Oh, one more wrinkle with double jeopardy that's useful to talk about is we've been talking exclusively about criminal law cases. It's very common, and it raises zero double jeopardy issues if we have a civil matter and a criminal matter about the same transaction. The classic example of that is the O.J. Simpson case. You may recall that Mr. Simpson was charged for the murder of his ex-wife and another gentleman. That jury acquitted Mr. Simpson of that particular crime. Obviously, in a criminal law case, the burden of proof that the prosecution bears is very significant. The proof level has to be beyond a reasonable doubt. The families of Mrs. Simpson and the gentleman, Mr. Goldman, I believe is his name, then sued Mr. Simpson civilly for the unlawful taking of Mrs. Simpson and Mr. Goldman's life, and they were successful. And so they were able to get a significant judgment against Mr. Simpson. Perhaps the reason they were successful in the civil court and hadn't been successful in the criminal court is because the burden of proof was very different. In a civil case, the burden of proof is just preponderance of the evidence. In other words, more likely than not that Mr. Simpson was responsible for it. There isn't any problem with proceeding either with the criminal case first and then the civil case, or the civil case first and then the criminal case. That does not raise any double jeopardy issues. Okay, and then we'll talk briefly about the due process clause. There's actually two due process clauses that we're concerned about in the Constitution. And the first is the Fifth Amendment one, and this has to do with criminal cases primarily. And corporations do have the rights in support of due process. And due process basically means that the government has to have a fair and reasonable process in place to handle criminal cases. I mean, think about it for a second. Imagine for a second that you are Bill Gates. You're fabulously wealthy, very famous, very smart person, has lots of attorneys working for you. You have a great deal of power and prestige in the world. But even you, and compared to the power of the United States government, you, Bill Gates, are a pipsqueak. You don't have nearly as many resources as the power of the federal government. For one thing, the federal government can imprison people. You can't do that. The federal government can put people to death. You can't do that. And so the power is always lopsided when an individual is dealing with the federal government. And that's obviously, if it's true for Bill Gates, it's definitely true for you and me. And so it makes sense that the Constitution takes some actions to give criminal defendants at least a little bit of parity with the prosecution. And we separate those rights into kind of two buckets. One is the procedural due process rights. Are the parties following a reasonable process under these circumstances? And then the other is substantive rights. We're not focusing as much upon the process, but now we're focusing upon what those rights are actually, are they actually fair? Are they actually not arbitrary under the circumstances? And now we have the last one, which is the takings clause, which is sometimes called the just compensation clause. This is the right of the government to engage in eminent domain or condemnation. Corporations are entitled to protection under the takings clause just like individuals. Whenever the government acts to seize land of private citizens or corporations, it is a controversial situation. People naturally feel very strongly about the property that they own, and they usually want to keep control of it. What this amendment to the Constitution says is it doesn't stop the government from being able to take the land, but it does require the government pay the current fair market value for that land. One thing recent thing that's happening in the press that I've been reading about is the proposal that a bullet train connect Dallas with Houston. Now, in order for the bullet train to be installed, there's obviously going to need to be a train track between Houston and Dallas. And obviously, if you're traveling at high speeds, the train track is going to have to be very straight. And so imagine that I own a ranch in the middle of this distance between Houston and Dallas. And it's a significantly wide, in terms of east-west ranch. And the bullet train developer wants to buy a stretch of my land, but let's assume in this scenario that there are no such thing as eminent domain rights. Well, I say to the bullet train folks, I'm not selling my land. And they say, but if you don't sell your land, we can't build the bullet train. We'd have to completely move it way over to another place, and we'd have to buy completely different pieces of land, and it would involve a significant detour. It would make the train that much slower. We won't be able to go ahead with it. And I could say, well, that's your problem. It's not mine. I'm just not going to sell my land, or I'm only going to sell it if I'm going to exercise my monopoly profit ability in these circumstances, and I'm going to extract a huge amount of money because I know that I have you over the barrel. But again, that's not how it works. The government is allowed to come in and take my land. They just have to pay me the fair market value for that. So we will, in the next lecture, begin to cover the Sixth Amendment to the U.S. Constitution. Thank you for your attention and have a wonderful day. As always, if you have questions about the material that we're covering, be sure to send me an email, stop by my office hours, or raise that issue in class. Thanks for your attention.